Good morning, everybody. Almost noon here. Thank you so much for joining us today. We have what I think will be an interesting, perhaps controversial at times panel here about new trends and potential new types of disputes that may come our way in the realm of mining-related disputes. Three Crowns is very happy to be hosting this. I think this is the fifth year that we're doing this, and it's been a pleasure to continue having great panelists that join us and present what is coming our way. I think that more than commenting on what is already here, I think it makes sense for all of us to ponder on what is coming our way, how we can be better prepared, both as mining companies, even sovereign representatives, and external counsel. So the idea today is to cover what I think will be four very interesting topics. We have two members of the 3C teams. We have Tom Bilden from the DC office here. My name is Augustin Sanz. I'm a partner with the Madrid office. We all work in mining-related disputes, but we also do a lot of energy disputes and other types of disputes. We do both commercial and investment treaty arbitrations, and I think that this is precisely the type of focus we want to have today, to get a sense of what can come our way, both in terms of commercial disputes stemming from the problems that we're going to be dealing with, and treaty disputes. So the governmental aspect of all this is also very relevant to us. Let me start by explaining how we're going to address these issues. We're going to have a conversation amongst ourselves now for about an hour or even less. And then we'll open the floor for questions so we can have more of a conversation on these topics with you. You're more than welcome to interject. So if there are any questions that pop up while we speak, your questions are more than welcome. But we will have time for Q&A at the end as well. So feel free to jump in whenever you feel that is the right moment. With that said, let me turn it to Tom so we can start.
All right. Good afternoon, everyone. I have the privilege to first introduce Dr. Janet Anderson to my immediate left. She is a vice president and the principal toxicologist with GSI Environmental based out of Texas. She has 15 years of experience in providing toxicology, risk assessment, and risk management support to federal agencies, the private industry, as well as municipal clients. And she specializes in communicating key findings from toxicology studies that inform state and regulatory policy, as well as public health decisions. So, Dr. Janet, in your role as toxicologist at GSI, can you describe some of the environmental risks that you have seen come up in mining projects recently, and any risks that may have the potential to turn into international disputes?
I'd love to. Thank you so much, and it's an honor to be here with you guys today. Thank you for the introduction. As Tom said, my practice is really at the nexus between evolving science, namely how our understanding about chemical risk, human health and environmental impacts from chemicals informs litigation trends, regulatory decision-making, public health, and stakeholder influences. So typically those are called emerging contaminants. So I specialize kind of in that emerging contaminant realm. How many of you guys have heard of per and polyfluoroalkyl substances? How about if I say forever chemicals? Oh, more hands. Okay, so forever chemicals is sort of the generic name or the nomenclature that's been assigned to these PFAS chemical class. And to answer your question, I think PFAS are the class of chemicals that are going to be on the horizon for the mining industry that's presenting the next environmental risk. So what are PFAS? Well, these are man-made chemicals, so completely anthropogenic, and basically defined as a carbon that's fully fluorinated. And so these carbons can be in a chain, they can be stuck on the end of a compound, but the fluorine and carbon bond doesn't happen naturally. So industry has decided or figured out a way to engineer these chemicals, and they're used in a wide range of specialty types of products. You might have heard of the aqueous film forming foam, or AFFF. That kind of was the big first product that really got well known for containing PFAS. But any kind of product that is designed to be highly stable, highly durable, withstand extreme heat, pressure, UV, I mean, anything that could normally break down a chemical. PFAS do not break down easily at all. So hence the name forever chemicals. They really are extremely persistent in the environment. So what we've seen is that the regulations around PFAS and the science evolving around their potential risk has been slow to evolve. So lawyers have stepped in, and there's been a ton of litigation, and really it's the litigation space that has driven the public awareness and the policies and the regulations around this class of chemicals. So these chemicals, again, are really persistent. They're also, unfortunately, the regulatory thresholds for protecting public health and the environment are at the PPQ, part per quadrillion, or part per trillion level. Excuse me. So basically a detect of some of these compounds in the environment equals an issue, equals a potential liability and potential human health concerns. These compounds are ubiquitous. They're found in so many things, and some of them travel atmospherically. So we've detected them in the Arctic. They're in 95% of human serum, so 95% of us in this room have them in our blood. And the initial wave of litigation was against the manufacturers, 3M, DuPont. You might have seen Mark Ruffalo in Dark Waters. That is PFAS, right? And then it went towards the installations, the military, the airports that are using AFFF. Those were the low-hanging fruit. Unfortunately, now the next are sort of these mid-tier industries that use specialty chemicals in their processing and products that may have environmental releases of these chemicals, and now are kind of faced with this patchwork of regulations worldwide, inconsistent interpretations of how to manage these compounds. So really, I think that's the long answer. It's these PFAS. Again, we're seeing this play out in other industries. For example, your oil and gas colleagues, they weren't sort of the low-hanging fruit. They're now kind of next. Chrome platers and sort of the plating industry, so downstream, for the metal, they use some PFAS in some of their products as well. So the writing's on the wall for PFAS coming to the mining.
You mentioned some interesting disputes in the United States, primarily where PFAS have played a role. Do you see this as becoming so much of an issue that it would play a role potentially in M&A transactions as a liability feature?
Yeah, I think PFAS are showing up not only in environmental liability, but in how are we defining what a liability and a risk is. So we're seeing it pop up in discussions around M&A for sure. How do you do your due diligence to determine if and when and how you might have had PFAS? So if there was historic use of the aqueous film forming foam or that very specific type of emergency fire protection, that's easy. But the reality is most of the products that contain PFAS don't have a big PFAS sticker on them. It's not listed in the MSDS. It's confidential business information, proprietary to make that product do its function. And so you don't know if you have a PFAS until you go testing. And I know lawyers are like, you want to test? Collect data? Are you crazy, right? But that is where we're talking. And we're seeing regulators ask for PFAS testing and permitting. We're seeing it in discharge limits and wastewater limits and stormwater discussions. Soil and environmental management plans. We're seeing it come up definitely in sort of this legacy liability discussion around mergers and acquisitions. So when you think about PFAS risk and you're thinking about M&A or you're thinking about any of these types of buckets where it might come up, sort of what did we use historically? Because they're so persistent. If you used it 20 years ago, even at small amounts, it might still be present. So what happened to that product? Where does it waste stream go? And what are we using today? Are we introducing a potential liability or supply chain issue? As the world kind of cracks down on PFAS use, we're seeing changes in supply chain that you may not even be aware of that may influence performance or may influence your liability.
So you mentioned your role in interfacing with the regulators about this issue. What do you think? Can you speak a little bit more about the incentive for regulation, not just in the U.S., but perhaps even civil law jurisdictions where there's a tendency to regulate these things from sort of a top-down level as opposed to waiting for damages in a dispute to come up and solve it that way?
Yeah, we're seeing sort of this potential damage, so this risk, this sort of you should have known. PFAS are persistent. Some of the PFAS have bioaccumulative and toxicity characteristics on them. Therefore, you should have known, you should have not, sort of in this ES&G world of sustainable products and managing your environmental liability, this sort of how dare you not know kind of thing. And even though it wasn't required, you should have known. How could you have not? PFAS is kind of everywhere. And so I do think, again, there's a long list of potential products that it might be present in the mining industry. And so we see this already playing out in product liability space. We're seeing it play out in oil and gas and other energy sector spaces, and in the defense and airport space.
I have a question for you, because it looks like it should be pretty straightforward to identify what type of products use this substances. First, is that the case? How easy it is to know whether you're dealing with this? Who are the usual suspects in terms of products that use PFAS? And what are the alternatives? I mean, is it a matter of just buying the alternative, or is this so indispensable that you have to address it from a prevention?
Sure. So the first question, would you know that you have PFAS? Unfortunately, the answer is no, unless it's aqueous film-forming foam, or unless it says perhaps fluorosurfactant or some sort of fluoro in the MSDSs, you're not likely to know. These compounds, because they're so stable, they are able to be used at such low concentrations in specialty products that they don't have to be disclosed. So they fall under the confidential business information and non-disclosure kind of loophole. Some entities, like in the US, are trying to change that, but slow and few and far between. So the list where I have it may show up, and this is a may, not only firefighting foam, but surfactants that are used to increase metal recovery, specialty lubricants and greases. We know that these can be, and especially ones that have to be really stable. Wetting agents used in processing, acid mist.
And sorry, when you say stable, just to get a sense of how this works, right? So you're talking about, for instance, preventing any given substance to flare up, for instance.
Right.
That's what you're looking for when you use these substances.
Yeah. Or a chemical that needs to be used in a situation that's highly caustic or high pressure or high heat and not break down itself. Like its presence is responsible for or needing to impart its activity. Acid mist suppression, foaming agents and drilling fluids, or flotation processes, or leaching in copper and gold. So therefore, because of all these products, it really might be in your wastewater effluent, in your stormwater effluent, in your pit lake, right? So thinking about, again, at small levels, if we're talking about a detection equals a problem that you then have to defend. And keep in mind, it's also ubiquitous. We have detected these compounds in the rain. So then you're like, well, is it mine? Just
how
because
do you
it's
trace
there?
that?
Right. That's a huge active area of research, of the sort of forensic source allocation part of what we do. Of whose PFAS is a hot topic.
So if you're dealing with parts per trillion, as you said before, so can one deflect a potential claim saying this is coming from somebody else using this and it's coming through the rain?
Not easily.
Not easily.
Not easily at all. Yeah. Those cases are ongoing for our colleagues in other industries right now. So they're playing out in the court system as we speak.
Wow.
Unfortunately, our analytical methods to detect PFAS are also lagging and coming, and so they have developed these detection capabilities where they just look for a carbon fluorine. They don't even know what chemical it is, but they say it's carbon fluorine, that can't be man-made, therefore it must be a PFAS. So we're seeing cases make it through at least to some to judgment and to trial. Based on just a detection of an organofluorine.
It's interesting because it sounds like there's almost a burden of proof issue where, by virtue of knowing that these are not organic chemicals, these have to be man-made, then the impetus is sort of on the industry, to prove otherwise.
Yeah.
One last question. So everything you mentioned about these chemicals, their uses for high heat tolerance, shelf stable, et cetera. This is everything that you listed was particularly relevant to mining industries. What do you see U.S. mining companies doing? How are they considering this issue?
I'm not sure that I've seen much, to be honest, and I think that's where I'd like to have the conversation of what can and should be done. I think what I'm seeing is other industries, because I've been hired by some of them, to help them be a little bit more proactive, do some upfront work underprivileged with legal counsel to develop sort of a desktop exercise of what is our potential liability here? What do we know either at a portfolio? I've had some clients doing it sort of at a corporate level, but certain clients are going site by site. What do we know about this, the history of this land usage? What was used here? Where was it used? Where did the soil and environmental media move? What are potential liabilities just at a desktop? No collection of samples yet. And because the regulations for PFAS are so disparate, it's a patchwork across the globe. It's even in the US, every state has their different regulations. These different facilities, then where are you in the regulatory process? Are you in a jurisdiction that's like PFAS, what are those? Are you in a jurisdiction that's being heavily litigated or a lot of legislation or regulations coming down the pike? And so I think from an industry perspective, what we've seen is a lot of work kind of behind the scenes because no industry wants to stick their neck out and put a bullseye on them, right? Yeah. But a lot of work with legal counsel and hiring some experts to do the work internally to try to figure out what is the PFAS liability for a given location or a given usage or
Since you said that there are no coherent measures taken by government to sort of prevent or address this ex ante, let's say, are there any efforts from the industry to come up with a set of standards or rules that can be applied so that they themselves self-regulate to provide what is a baseline to deal with these substances?
For sure, and I didn't answer your question about replacement. So it is a little complicated. In the manufacturers, the fluorochemical manufacturers themselves, changed their manufacturing process and changed the PFAS chemistries that they used because of the intense regulatory pressure and all the lawsuits that 3M and DuPont. So manufacturers themselves have changed the formulations. So historic stuff, the exact same formula of the exact same product, if you bought it 20 years ago, it might have a PFAS that's more problematic than today's formulation. But it's still a PFAS. And what we saw play out horribly in the AFFF space is that replacement products are few and far between that have that type of stability and durability. So we're seeing carve-outs for specific industries. So medical devices. PFAS are used in some implantable medical devices because you don't want those things breaking down. So catheters, pacemakers, we don't want those breaking down in our bodies. Those sometimes get exclusions. Some PFAS are greenhouse gas replacing, so the hydrofluoroolefins and hydrofluorocarbons. Some of those are PFAS. Well, we don't want to go back to greenhouse gas, hydrochlorocarbons, right? So some of those get carved out. Some of the discussions around pharmaceuticals are getting. So I think that's this issue of critical use. In the United States, the Department of Defense issued a report about a year ago where they identified PFAS critical uses throughout their portfolio of defense that they said there are no suitable replacements and it will impact harm on the ability of U.S. DoD to
It's a matter of
protect.
trade-off and say, okay,
That's
we
right.
have to deal with this.
PFAS are
It's
used.
about due diligence.
Yeah.
Is that the discussion? So how do you deal with
How do you
something
deal with
we
it?
cannot avoid?
Yeah, and so the reality is it is expensive to make these chemicals. So they're not just around for fun, right? They're in specialty products, but those products have very, very specific and purposeful uses. So getting rid of them or changing the characteristics of that product may have potential detrimental effects on the purpose of that product to begin with. The Space Shuttle Challenger, if you guys remember that, it was determined that the failure of the space shuttle was the O-ring, right? Well, that was made with a silicon-based product. Today, they're made with a PFAS-based product because it can withstand that extreme.
More stable.
So I can assure you we're not replacing it there yet, right? Now, there is some that argue, well, if you put pressure on manufacturing, that incentivizes, ingenuity and R&D, and we'll see some changes there. But I don't know throughout. Maybe a good example would be hexavalent chrome mist suppressant. So when you plate hexavalent chromium on the real shiny bumpers, to limit the hexavalent chromium mist, we use a PFAS-based mist suppression. There was no other product that worked, but industry worked on it. It took them a while, but now on the market, we're starting to see replacement products. And same thing with the firefighting foam. We're starting to see replacements, non-PFAS-based products. But it takes a while, and it takes industry working together to identify the products, identify, are there suitable replacements, yes or no? What are we willing to work with as far as a replacement?
It'll be very interesting to see how the mining industry sort of adapts. And speaking and picking up that thread of the mining industry, I want to turn the conversation now to international mining projects. And for my colleague, Agustin, I want to discuss the issue of international protections and where we've seen some interesting developments when it comes to the full protection and security standard in international law. So Agustin, could you first explain to us what exactly is this full protection and security standard and why it's relevant today?
I'll give it a try, at least. What I would say is that the full protection and security is something that we've had in investment treaties or commerce treaties or friendship treaties dating back 200 and change years. So it's nothing new. The problem is that the definition is kind of vague. So what is full protection and security? Some treaties do deal with these protections using the full protection and security nomenclature. Some others say protection and security. So we have the full out. Whether that has an impact or not, that is something that is debated. But what I would say is that it is about the state not harming the investor or the investment with actions that may be attributable to the state, but at the same time, it's also about what the state is in a position to do to prevent harm to those investors or investments in situations where, for instance, the use of force or the use of police powers, more generally speaking, can be deployed to prevent those situations, right? So it's not just dealing with actions, but also potentially dealing with omissions by the host state in protecting those investments. Now, again, as I mentioned before, it's interesting because I would say most every treaty, bilateral investment treaty or the chapter on investment from different FTAs, free trade agreements, contain some sort of full protection and security guarantee. I mean, it's rare to find one that doesn't. But the reality, again, is there's a lot of discussion as to what is the scope, what is the actual content of that guarantee, whether it's exclusively dealing with physical full protection and security, meaning I have, say, a bunch of local stakeholders that are opposing a mine that is in the first phase of constructing or building the facilities they need, and you have local stakeholders step in and say, we're not going to allow trucks to go into the site. So that seems to be a pretty straightforward answer. It's a yes. So that would be something that maybe potentially engaging the full protection and security guarantee. But then the question is, does that include legal protections or commercial protections as well? And this is something that has been debated over time by investment tribunals when there is no definition, clear definition coming from the treaty as to what is the scope of this protection. And so there have been some instances where claimants and tribunals have considered the possibility of considering that legal protection. So basically, instances where, say, keep the same example, right? You do have local stakeholders step in. They try to take over, say, a site where you're developing a mine. And the question is, besides the discussion about the physical protection, is there legal recourse? So basically, can I go to court and have this group of, say, indigenous people that have taken over a site? Can I have the courts order police powers to step in, remove them from the site, and allow me to continue working? Are those legal recourses part of this analysis? And this is pretty much something that is evolving in the context of full protection and security discussions. Now, I want to be very clear about certain things because it might call into question whether what I have is an obligation of means or results, right? So is it about governments being on the hook for a full protection and security? That means that whatever interference I may be facing for the development of my mine, something that will qualify because they need to take action, or is it a means discussion? Is the government exercising reasonable diligence in providing the assurances that are necessary for me to develop a mine? Is it something that is pegged to the capacity, the actual capacities and abilities that a government has? And this includes the economic thrust that a government can put into this. So are we talking about a very well-developed country that has a number of means that can deploy to avoid this type of issues? Or are we talking about 3 policemen to cover a vast area where it's very difficult to control the situation everywhere? I will get into details, but this is part of the discussion. So what I would say as a first line of argument is that it's not a guarantee that will allow you to say anything that happens to my investment will trigger this protection under a PAT, unless there's clear definition to that extent in the treaty. It is more about the diligence that the government exercises in taking those measures that are reasonable in the context. And that is already hinting at one of the things that I guess we're going to be discussing, which is the importance of the factual context. What country are we dealing with? What is the region like? What are the reasonable measures that can be exerted in a given context? So it'll be very fact-specific, and that means that there's a lot of work for lawyers in discussing this. And just to clarify, we're not dealing with a strict liability type of discussion, right? So it's not that if I manage to prove that there has been harm because someone stepped into my facility and disrupted my operations. It's going to be, again, about a much more demanding test of seeing what is reasonable in the context. And that means a lot of work for claimants. And this is what actually has been happening with case law throughout the years.
So the work that parties should do to document this, I want to get to that in a second. But first, you used the word evolution of this sort of standard. And it seems to be there's, if not in precision, there's certainly some sort of fluidity in how the standard's applied. Could you discuss a little bit about what the evolution has been recently for these full protection and security cases, and any takeaways that may be particularly relevant for folks in the private sector, particularly in the mining industry?
Let me, I guess, focus on 3 things that I think are relevant. First, and as I mentioned before, I think there's a lot of discussion as to what is the scope of the protection. I mentioned before that this tension between, is it just physical protection? Is it legal and physical protection? I think this is something that is fluid to a certain extent. I think treaties, for instance, have been dealing with this in carving out, making it clear that this is about physical protection, and whatever claims you may have, say, for lack of legal recourse, have to be dealt with if the treaty so provides through, for instance, denial of justice rubric, or fair and equitable treatment rubric, which is a different kind of claim. So the first point of evolution, again, I think it is coming from the treaties and coming from the case law, trying to define what is the scope of this protection. In general terms, I would say that this is, again, becoming more and more fact-specific. It's more and more context-specific as well. It's not just facts, but the context. Again, what type of players are we dealing with? Because it's not just about proving whether the government was in a position to do something, but it's also about making it clear for the tribunal whether you as a private investor were doing whatever was in your power to do to prevent those situations, and whether, for instance, you had a sufficient level of cooperation with the government in dealing with these situations. So I think it's becoming a very fact-driven discussion that is very interesting. Let me address a couple of additional points. I think that in terms of the burden of proof of all of this, I think that it has to be very clear that because it is a fact-driven discussion, because it's a context-driven discussion, I think it's going to be difficult, to be fair, to establish a violation of this standard unless investors have been particularly meticulous in keeping track of what's going on with the site. Say you're dealing with a mine what's going on with the site, what have you been doing before you deploy your investment to anticipate what may happen, what kind of dealings have you had with local stakeholders, with the police department locally to make sure that they had all the tools necessary to address these situations. So I think that there will be scrutiny of what types of relationships are built by investors and how governments become or not an ally in that effort. Because again, it's going to be a complete failure to address these issues with reasonable diligence that is going to trigger this type of protection. And this is pretty much part of the discussion, particularly, for instance, in Latin America right now. A lot of discussion about social licensing, how you get to start a mining project in the region. Now it's not just about that. Now it's about, okay, I already have the license. I can start working there. I have done my homework in that respect. Then I start operating, and then what I have is a situation where local governments and national governments may find themselves between a rock and a hard place, because on the one hand, they want the revenue coming from the mining industry, and that is all fine. Even local governments want to maximize and extract whatever benefits they can get through social licensing, let's say negotiations, to get the most out of mining projects. But at the same time, local stakeholders are very visible, you know that, and they, if they have protests in place, they block production in certain mines. All those things are very relevant to this discussion, and I think it's a very delicate equilibrium. So I think it's evolving. Let's see how it goes. I see here, I have a colleague over there that we've been fighting about this specific standard not long ago, and I mean, it's fluid. Am I right? It's fluid. Yeah.
For the record, it was a thumbs up, so agreement in the fluidity of the standard. So, Agustin, you spoke about sort of the factual exercise of keeping a clear track record of what was promised, what was done. Can you expand a little bit about what the private industry can do and what governments should do as part of this exercise, looking forward to, in a world where there's potentially more potential for sort of disputes involving the standard?
Yeah. The first one, what I would say, is a baseline, and it's a complete baseline. You have to keep a detailed record of what's going on. I think that is critical for both ends of this discussion, right? So you want to have a formal instance of exchange where you can deal with this situation, because it's going to be protective of both parties' interest to have a clear record of what has been asked from whom, how was that request specifically addressed, because that is the starting point, so that you can then say whether there is a breach in that reasonable measure addressing the underlying concern. So I think keeping a record is fundamental. I think tribunals have been paying a lot of attention to whether this is something that has created actual disruption, actual damages, because not any situation will trigger a full protection and security finding by a tribunal. So the second thing is not just what is happening, but what is the impact of that something that is happening that I'm getting in my everyday operation, be that days that I'm not able to run the facilities, if I have problems getting, for instance, as we had in a case, getting the employees of the mine into the site, because perhaps the facility, no problem with the facilities, but they don't allow workers to go in. So you need to make sure that you have a clear account of what is happening on the ground almost on a daily basis, so that you have the track record. I think that is fundamental. And I think that then my impression, and again, we'll open this to the floor and see if others have different views. I think that it is not enough to have formal conversations. You need to have substantive conversations. So you really need to show that you have been willing to address this issue in a cooperative manner with the state. And even in that context, state action has fallen short of what should be, if you're looking at it from the investor's perspective. So I think that there's a lot that can be done in terms of being proactive. again, the first step is going to be social licensing and how you prevent anything from happening. But once you're dealing with this, you need to make sure that you have secure channels and on-the-record channels to deal with all of this in case you need to substantiate this in arbitral proceedings. Yeah.
Excellent. Well, now maybe we can move a little bit about what the state's obligations are and discuss a little bit about the regulations that impact corporate activities abroad for mining interests.
Yeah, and I think that for that, let me introduce Gustavo first. So Gustavo Morales to my left. He's guilty of being Argentinian, as I am. And so, but he moved from Argentina to Canada a couple of years back. He was a partner with Marvalo Farrell. Maybe you know it. It's a leading firm in Argentina, specialized in anti-corruption, FCPA, and let's say white-collar type of thing back in Argentina. And then he decided that he wanted to change gear and make it to the big leagues. So he moved to FTI as an expert. He deals with investigations for sure, with expert evidence if need be in terms of corruption. And at the same time, he does deal with disputes and forensics, both here based out of Canada and in Sao Paulo. So he splits his time. It's a pleasure to have you here, Gustavo.
Thank you so much.
And I guess that with that introduction, we can turn to the next topic we have, which is certain news that we got from the White House.
What are you talking about?
Yeah, there are tons of news coming from the White House. But let me say that we heard recently that the U.S. administration decided that FCPA was on hold. And so the first question to you is, can you explain a little bit what is this decision, what is the scope of this decision, and what is the impact it might have in terms of FCPA applying to U.S. companies?
Sure. Let's relax the conversation talking about FCPA. So first of all, thank you for the invitation. Happy to be here and have this, hopefully, conversation with all of you. The first point that I need to make, as Agustin explained, I'm a consultant now. I'm not practicing law. But I should say that the FCPA is not on pause. It's enforcement of the FCPA that is on pause. That being said, just in case somebody is not familiar with the FCPA, which is, a super interesting topic for people like me, but I understand not for everybody. Just to be clear, this is a statute, enacted by U.S. Congress in 1977, making it illegal for companies and individuals subject to this U.S. statute to pay bribes to foreign public officials. That means non-U.S. public officials. In 1977, a lot of discussion, took place. The law was, enacted. Nothing really happened until early 2000s, where we started seeing enforcement picking up. And then the FCPA became a big thing, right? Everybody at the law firm could easily, track down the growth of a compliance or a white collar, an investigations practice, right? Even an FCPA practice. Great practitioners were coming out of DOJ, moving to the private sector, and this kind of market grew significantly. The FCPA became the leading anti-corruption statute around the world. The US pushed really hard at the OECD for other countries to adopt similar statutes. So many other countries, from the UK with the UK Bribery Act to even Argentina, right? We see all of these similar statutes making it a crime to pay bribes to foreign officials all around the place. On February 5th and February 10th, two big news happened with regard to FCPA enforcement. So on February 5th, 2025, this year, just a few days ago, there was a memo by the Attorney General in the US which clearly states that FCPA enforcement should focus on cartels and organized crime. So we are talking about bribery related to cartels and organized crime. A few days after February 10th, there was an executive order by the President of the United States pausing FCPA enforcement. So we have enforcement, okay, hit pause, that's it. Which is kind of an unusual concept, right, for lawyers, right? I mean, we are pausing enforcement. What's the meaning of this? So I strongly recommend everybody to read both the memo and the executive order. There are dozens or hundreds of articles written already by lawyers and consulting firms, about this. If you go to the original documents, you will see the details of what's actually happening behind, these two so relevant pieces that are impacting this particular statute. So the decision made by the White House, this executive order, pauses enforcement for 180 days with one particular purpose, which is to have the Attorney General, DOJ, issue new guidance on the FCPA. This is critical, right? Because the FCPA, I'm not talking about other statutes, but for the FCPA, there is specific guidance on how to enforce this particular statute that gives some clarity to lawyers working in this field, but also to companies exposed to this kind of statute. So the new guidance shall be issued within possibly 180 days, because the Attorney General has the capacity under the executive order to extend that term for an additional 180-day period. So we're looking at a 6-month to 12-month time frame here. And the reason for the new guidance to be issued, as established in the executive order, is to focus FCPA enforcement on US national security matters and US economic development matters. So then we start seeing how, an anti-corruption statute could be connected to economic development, economic activity, this kind of disputes that we are talking about today, the activities of the mining companies. The question is, how do we make sense out of all of this? Well, it is what it is, right? There is no way to fight it. But we need to understand and clarify a few things here. The first point is the FCPA as a statute remains valid, and it's in force. But the people pushing investigations to identify who committed a breach of the FCPA are simply looking some other way for a few, let's say, months, right, according to the executive order. And this is critical to be properly understood, because when people read quickly, I mean, this is, we live in Instagram or TikTok, not even Instagram. Instagram is already old, right? So we live in TikTok days, right? It's like a 3-second thing and I'm out. Okay, next one. So let's get down to real life here, right? Go beyond the legal analysis. We are talking about mining companies, mainly in this room, who operate in a number of countries around the world. If you look at any kind of reports on levels of corruption, many of those countries have high levels of corruption risk. And if you have the wrong people at your companies reading the wrong pieces about this executive order, they may so easily get the idea that the FCPA is over, terminated, or like Agustin likes to say, abrogated, okay? So it's all good for corruption now. That's definitely the wrong idea. That can get too many companies into too big trouble, right? And actually, if you take a quick look, if you simply Google, FCPA executive order pause enforcement, and you look at different publications, there are so many newsletters from law firms which are super precise. I mean, we love, discussing words. It should be pause enforcement or this or that. Very specific. But there is also wide coverage by journalists, by just regular media, particularly in Latin America, for example. Kind of headlines like, it's all good for corruption now. So it can get really, really, really tricky. That being said, it's also important to keep in mind, in terms of what's going on about all of this, that the new guidelines, as established in the executive order, shall be applicable to new investigations and to ongoing investigations. So if you are going through an FCPA investigation now, which you may or may not know about, the new guidelines may have a significant impact on how those investigations will continue for the future.
But on that point, Gustavo, I think that from what I hear from you, two different things may be happening at headquarters and wherever you have operations overseas, right? Because at headquarters, you may be saying, okay, if I caught wind of an investigation that is coming my way, maybe we're celebrating because the guidelines may have a positive impact on whatever I'm doing.
Maybe.
But at the same time, I may be in a situation where local management of one of my subs overseas says, okay, gloves are off. I know that people coming from other jurisdictions, say, I don't know, China, whatever, they're not subject to such stringent rules in terms of how they deal with government officials. Now we're off the hook. We can go back to businesses as usual, let's say. You step off the line. This is not being enforced at the moment, but this can become a poisonous pill that you have to deal with, both in the context of, I'm thinking, M&As in the future, if you're running proper due diligence, or potentially other types of dispute. Am I getting this correctly?
You're getting it absolutely correct. I mean, again, when you work in this field for some time, you realize that, you know, in practice, in real life, corruption is never an isolated situation. It's never that we had just one container that was super relevant to our operations in whichever country, country A, so we don't name anyone, okay? Country A, and suddenly, you know, the people involved in the company decided to pay a bribe. That happened 5 years ago, never happened again. I have never seen one case that goes that way. So in practice, corruption, you know, goes down a slippery slope where people begin with, you know, small payments here and there, under the assumption that everybody is doing it. And it never stands still. It grows. So it grows in terms of payments of bribes, in terms of the amounts involved, in terms of the frequency, in terms of the company actions in which the bribes actually take place. It grows in terms of how even protected people feel. I've seen more than one case where, you know, massive global companies were recording these bribes in their accounting books. I'm talking about companies who hire lawyers like you guys. I mean, companies who are as sophisticated as mining companies present in this room, right? So people start going down that slippery slope, and they start moving from bribery into, well, I mean, it's bribery, but I mean, it's small tax fraud. It's not that much of an issue because it's small. If small bribery is not an issue, small tax fraud is not an issue, right? And from tax fraud to money laundering is kind of just a couple of steps away, right? So either you keep things under control, or you face a big risk that may impact all of your business, right? And that may also have an impact on any disputes related to those businesses. So when people ask me what is the best way to prevent all of this from happening, I say make sure you communicate the right message. Make sure you anticipate the message to your decision makers in those subsidiaries far, far away. I mean, the traditional mistake is thinking that, whatever, let's say we have a mining company headquartered in Toronto. And I know how you think, you know how I think. We would never do this, right? But suddenly we have some operations in a remote place of the world. I mean, yeah, we sent a couple of emails and they signed a few policies over there, you know, our employees. But you need to really anticipate what they're going to think. Send the right message, establish the limits. And again, in terms of how will this executive order and the Attorney General's memo actually impact standards, controls when it comes to corruption? Again, keep in mind, the statute remains valid as it was 6 months ago or 5 years ago, right? So any decisions a company may make trying to relax standards, trying to take advantage of some, let's say, business opportunities, right? Which the idea of a business advantage is part of the requisites in the FCPA, could be really tricky. Because even if no enforcement happens today, no investigation is initiated today, or an existing investigation is not pushed forward today, all of these actions are subject to a statute of limitation that is longer than the term for an administration, let's say under the US government. There is exposure under so many other laws in different countries.
And authorities, right? Because SEC, for instance, is not bound by whatever DOJ has to say about this, right?
Great point, great point. So we are talking about a pause on enforcement by DOJ. The SEC, who pursues civil enforcement of the FCPA, is not subject to this executive order, so it remains to be seen how they are going to react. There are contracts that companies have signed which often establish compliance provisions that require compliance with the FCPA. So if you don't comply, you may be in breach of contract.
It's a matter of contract and irrespective of the memo.
Irrespective of the memo, exactly. And irrespective of how the authorities behave today, again, think of the slippery slope of corruption in practice. These actions never happen in isolation. They may tend to happen for years.
So you do have exposure even from governmental agencies, and even in the context of this pause, let's say, then you have potentially, I'm thinking in the context of M&As, you may have valuation discussions driven by whatever your due diligence finds in this context, or you could have potentially post-M&A discussions because of something that pops up after the fact.
If you're extremely lucky, you will have a valuation discussion. Most of the time, the buyer will simply walk away, because one of the many big challenges with corruption is that it's not so easy to properly understand the scope of what actually happened. Okay, when people are, truly careless, and like I said, they go ahead and just record, and there are any arguments. I mean, these are facilitation payments, so we were recording them on our accounting records because they are good, they're valid under the FCPA, right? And then when you look at it, there is no way these are facilitation payments. Or because people think, and I'm talking about real life cases that I've seen, that I've worked on, and not like a book, right? People say, well, but I was not just handing out money. Let's suppose I import and distribute laptops. I was handing out some laptops, to the customs broker. I mean, that's not money. I mean, just inventory, right? People do it. And if you give them the opportunity, they will do it. So when you have a buyer who is interested in acquiring either your company globally or, part of your company, or entering into a joint venture, or acquiring a subsidiary somewhere around the world, typical situation. You decide that particular operation in that particular country makes no more business sense for the company. So we are out. Okay, find me a buyer. Okay, find me a buyer. Buyer comes in. Buyer hires a law firm. They would hire us. We do the due diligence, and 5 days, we can see if there are red flags. Some buyers, depending on the risk profile, they would say, dig deeper into this. Let me know if there is a number that we can bring to the table to negotiate the purchase price. But many buyers, too many buyers will say, I'm not touching that. I'm out. I'm simply out. Right? And this happens in real life. The point is, nobody advertises this. Nobody goes on Twitter, and comes up with the news. We just lost a potential deal because of this. We just realized that, our subsidiary in this whatever place in the world was behaving this way. So I promise you, for every case that you learn about that is a public case because there was a settlement with any authorities or whatever, there are dozens of cases that nobody hears about. And many executives, maybe like some of you, are just simply crossing their fingers, waiting for the news not to go out.
And there's an additional problem, I guess, for us coming from arbitration, and in particular investment arbitration, because we all know that the defense of corruption for government saying this tribunal should not cease jurisdiction over a certain case because there's corruption in obtaining this contract or getting certain rights under this contract and whatnot. So you should refrain from taking on this case. So you may also be weakening your legal position vis-a-vis the protection of your investment by, again, disregarding standards that may be relevant to you, even if you don't care about FCPA, right? So you may have your own drivers, irrespective of the pause of enforcement. And so you get a signal from the administration saying, gloves off, and then you have an interest in keeping those standards on because that's a way of protecting your investments overseas, right?
Definitely. And always keep in mind that the FCPA remains to be the leading anti-corruption statute around the world, not because it's the best one in terms of the wording, but because the draft is perfect or crystal clear. It's because of the enforcement. So far, it's been the most enforced anti-corruption statute around the world in history. Okay? It remains to be seen what happens from now on. But there are other regulations that make it a crime to pay bribes. I mean, paying bribes has been a crime since forever, hundreds of years in criminal codes everywhere. So one thing to keep in mind, going back to your point, Agustin, is a very hard lesson that we see, companies, let's say clients learn down the road is whenever they face a case of corruption, pretty soon they learn that they are not in control. And that's challenging. Because if I'm operating a mine in a certain way, I'm not an engineer in mines, okay? But I mean, I can make changes. I can change whatever, the strategy, the methodology, the machines that I use, whatever, right? But when there is corruption involved, the minute you start investigating, because you identify a few red flags and you start, pushing a few buttons, asking a few questions, there is so much data these days. So much. We have hundreds of people at FTI who simply analyze all kinds of data, and they will find the connections and start to, make those red flags even bigger. And at one point in time, the people at the company learn about this. And there is always somebody who can be exposed to individual liability. And these people are not talking about paying a fine and just fixing the problem. They know they will most likely go to jail. So that's not a friend for the company. And these type of situations, may super easily get out of hand. There are journalists, there is, social media. It's really, really difficult to deal with this type of situation.
And again, the lawyer in me, and we'll get back to this if we have time at the end, because now I want to turn to Tom, but it brings all sorts of evidentiary issues, right? Because then you may have an official from the company becoming a key player in whatever a state is saying as a positive defense of corruption in an investment treaty case 10 years down the line, right? So
definitely.
Yeah.
Can I just ask really quickly on that, because you raise a very interesting point, Gustavo. You identified essentially two issues why this FCPA pause should be more or less irrelevant for mining companies doing business overseas. You mentioned one, there's probably other legal codes prohibiting corruption that may apply to the project. But two, you mentioned that as a matter of efficiency, which is a great point, that corruption is essentially a form of inefficiency. When I was reading the White House's press release on this FCPA pause of enforcement, the purported reason behind it was in order to make presumably U.S. companies primarily more competitive abroad. Do you see the result of this executive order completely being sort of contrary to its purported purpose?
Couple of points there. So, competitiveness. So, first of all, this executive order, so the pause on enforcement should not be relevant to any company. Mm-hmm. It actually increases risk. Mm-hmm. Because if the company's decision, it increases the risk, mm-hmm. because it decreases the perception of enforcement. Oh, if I'm not a lawyer, I'm an engineer in whichever country, I don't like naming names, okay, in the country C. I'm an engineer, I'm dealing with the mines, whatever, and suddenly I read somewhere, somebody sends me an article about, the US stops enforcement of corruption.
Free laptops.
Okay, got it, guys, got the message, right? So let's rethink our strategy about those licenses we are not getting, in our favor. And people, when people are in real life, Let's talk real life. When you have somebody dealing with a business difficulty, challenge, problem, and they get exposed to a potential solution, they usually implement. They don't start asking questions. Yeah, I heard about this. Nobody said otherwise. So what is the issue now? So this situation definitely increases risk, because for lawyers, any lawyer who reads the executive order and the memo should not have a difficult time, making a mistake. They will understand the difference between enforcement and the validity of the statute. They will read between the lines in the memo. And actually, let me read this to you. It's super, super interesting in the memo. There is a paragraph particularly about the FCPA, and it goes about like this. The Criminal Division's Foreign Corrupt Practices Act unit shall prioritize investigations related to foreign bribery that facilitates the criminal operations of cartels. Okay. So if I'm prosecutor,
I'm not a cartel.
FCPA, I should focus on cartels. If I'm a company and I'm not dealing with cartels, which is a different discussion, right?
Yeah.
That's a different discussion. Which are cartels? I mean, how companies get exposed to them. But the order here is think of FCPA about cases connected somehow to cartels. And the same paragraph goes along as follows. And shift focus away from investigations and cases that do not involve such connection. So the message there is whatever cases you are handling right now and past cases, if you look at the history of FCPA enforcement, which I don't want to make this too boring, but usually it's the history of FCPA settlements. Almost, I think every single FCPA case involving companies has been settled. Just individuals would go to courts to see what a judge has to say.
So presumably, to begin with, what you have now is a big incentive for DOJ to settle whatever is not going in the cartel direction, let's say. Let's get rid of all those because my attention has to shift away from this.
But the problem is that all those are those cases where companies could be paying bribes to gain a business advantage, so long as the cartel is not involved. Okay. But that's enforcement. That's not changing, the word of the statute.
Tom, let me turn to you because since we're dealing with investment overseas, not what happens necessarily at headquarters, but what happens elsewhere, and the connections with those subsidiaries you may have, and the things you need to import and get for your production lines. We've all gone through the pandemic, and one of the, headlines we've all seen in the newspapers is there are problems with supply chain for whatever you need, right? Be that microchips or anything at all. So what have governments been doing to address this, and how can we find this issue to be relevant for mining companies and ourselves as dispute lawyers, how this can pop up?
Yeah, so I think we've heard a lot about supply chain disruptions and a need to ensure robust supply chains, particularly in the context of critical minerals, which in of themselves is very interesting because the term is actually quite amorphous, though many different government agencies have defined it. And it's actually ballooned. So the Department of the Interior in the United States in, I think it was 2018, published its list of critical minerals, which I think was a total of 35. This is now ballooned up to 50 and now includes some pretty common minerals that would be relevant to many of the folks that are probably in this room or that are presenting here at PDAC. In 2022, nickel and tin, I believe, were introduced. And then in 2023, copper was introduced as a critical mineral, as was aluminum, or bauxite, the precursor for aluminum. So we're starting to see in the critical mineral space that this is actually impacting fairly common sort of mineral trade flows for complex and run-of-the-mill global mining operations. What's happened in short, and I'm happy to talk with anyone afterwards in detail because I think this is such a fascinating area that will likely lead to a greater potential for disputes, is that there's because of different government regulations, I think we're starting to see a bifurcation in supply chains. One that's going to be essentially centered upon a North American, Western European, for lack of a more precise description, and the other related mostly to China side refining and consumption. And the impetus for this bifurcation has actually gone back quite some time. I know that President Trump's executive orders have gotten a lot of attention as we wake up with our morning coffees and struggle to figure out what's happening today and tomorrow. But actually in 2017, he had one in 2017, one in 2020, he had two executive orders about safeguarding the U.S.'s critical supply chain for critical minerals. And the big mover, I think, was probably under the former administration, under President Biden, the Inflation Reduction Act, which came out in August of 2022, which basically created a bunch of very lucrative tax incentives for companies that would basically onshore their critical minerals refining processes, particularly in relation to battery technologies for electric vehicles. And so what I think we see happening, just to speak in very broad strokes, is that you have more government sort of regulatory intervention when it comes to determining how the private sector starts to build out these projects. The Inflation Reduction Act, one of the things that it said that I think is very important for everyone in this room is that the tax incentives for these electric vehicle batteries would be applicable for companies that did the mineral processing for battery components either in the United States or in one of the now, I think, 20 free trade partner countries of the United States. And so what you see is that it's actually sort of dividing most of the world where the resources. So for example, Chile, Peru are part of those FTP member nations, but Argentina is not. And so what do you see is that, well, you see a lot more Chinese direct investment into, for example, Argentine lithium brines. And so you're starting to see, I think, trade flows become affected by these national policies. And then I think the next step to that is that obviously would increase the potential for international disputes.
Now, if I'm understanding this correctly, we may have the potential for two types of disputes, right? Because if you're thinking about commercial disputes, and I'll start with that one, there seems to be room for efficient breach type conduct, right? Where you say, okay, I have this incentives here at play, I'm going to react to them, and if I need to do away with whatever obligations I may have engaged in, I'm going to walk away because this is way more convenient, then deal with the consequences. Is this something that makes sense?
Yeah, I think that absolutely makes sense. I think on the commercial side, that's going to be an area that's certainly worth sort of keeping note on. The other part to this too is that it's there's also a bunch of very interesting sort of retaliatory orders that have come out from the Chinese government. So, and these have happened very recently. So, graphite there was an export ban on, or actually it was a change in the licensing requirements for graphite that came out, I think, in October of last year, and then in November, germanium, gallium, some other sort of more exotic minerals, they had a total export ban to the United States. And then just a couple of weeks ago, one mineral that I think is highly relevant because it's very common in copper and silver projects is molybdenum. There's been an export ban coming out from the PRC as of last month. And so I think you're going to start to see where especially projects and the entire value chain where you have a lot of the refining capacity still in China, particularly for things like molybdenum, I think you're going to start to see a lot more commercial pressure. And then this sort of, going one step beyond from the commercial space of disputes, there's also potential for sort of investor-state disputes, obviously. And so and this kind of ties up, I think, sort of the themes of this entire panel today is there's sort of this evolving scope of what the actual protections are for not only full protection and security, but full and equitable, fair and equitable treatment, for protections against illegal expropriation without just compensation. And I think it may rise to a new sort of chapter of interesting and very complicated investor-state work. I can't think of any clear examples of where this has happened before. except for one case that came out, which is the Vattenfall v. Germany case, which was, Vattenfall, I think, was a Swedish investor. I can't recall it precisely, but they were investing in the nuclear industry in Germany. And then after there was actually two separate cases, but after the Fukushima Daiichi disaster, Germany basically had a bunch of regulatory policies that essentially start mothballing its nuclear program. And Vattenfall brought two claims. They argued claims that would be very familiar to international arbitration lawyers, including direct expropriation, indirect expropriation, fair and equitable treatment, full protection, security, et cetera, et cetera. And the case ultimately settled. And it settled, I think, in 2022 for a pretty handsome sum. I think it was about 1.5 billion euros, where the overall claims, I think, were just about 4 billion. And so I think that's a sort of an interesting, obviously not precedent, but an interesting example of what could come as we start to see more sort of retaliatory measures coming from the US White House, but also from Beijing.
Interesting. So we're going to wrap this up. As you can see, we tried to pick topics that definitely seem to be things that will be on our radars for a couple of years at least. Very interesting topics. But at this point, I think it's useful to have your views if you want to comment or ask any questions before we go and grab something to eat. This is the time. So the floor is open. Yes.
We heard the changes in the U.S. and PFAS was a trend that was going at a faster speed in the previous administration. It's basically state by state.
Yeah.
In this industry, particularly it's chemicals and fluids, hydraulic fluids. And as you mentioned, people look at the 3Fs, fluids. However, I think there are trends now that are changing. We have a Supreme Court case, the Chevron case, by which agencies cannot regulate as they did before. We have different states going to different things. For mining and oil and gas, Colorado's a bad state, or we don't know yet. In Mexico could be a bad state. And then you have, of course, CERCLA, and those regulations that may not change. On the other hand, you have the EU coming with trending policy that is even harsher enforcement. And Trump comes in, and the EPA will probably slow down some of those efforts and be a little bit more business friendly. However, those two trends have an influence in how this is affected in other markets.
Yeah.
I will not name names. How do you see that working? Because when we work with our clients, and there are different aspects of these, if I'm going to start operating, I need to do diligence. I need to look at how we operate. I need to look at the site.
Yep.
I need to look at my vendors. It's a little bit of what you do with FCPA, because you look at book and records and third parties. But I look at my vendors, and I had to say to our clients, look, if you're operating and you're using chemicals and fluids, this is what you need. First line of defense, I ask you for a certificate about your chemicals, what you have in there. And when you give me the form certificate, I said, you didn't disclose this to me. And if they did, I start to carry a little bit of that problem. Then I go to the indemnities, how I release. What else have you seen? Because when I put my hat on and finance these projects, I start asking for disclosures and see how it was done. But this was done before PFAS.
Yeah.
Most of us,
Right.
I should say. What else do you see with all those trends on the government side and on the industry side coming to?
Yeah. Whew. That was a long and a really great question. My crystal ball is broken a little bit, but unfortunately, what I'm seeing happen, at least in the U.S. and even globally in other jurisdictions that aren't quite as sophisticated or don't have this robust sort of science-driven process, is they're just passing legislation that is either restricting certain products in use without even defining the chemistry correctly or without understanding the implication. And I think we'll continue to see that. So I think we really, as an industry, want to just be advocating for reasonable regulations and legislation, paying attention to the state legislation process. And then as far as just how we advise our clients, that's when the lawyers come in, and I see a lot of work around contract indemnification clauses, insurance policy carrier clauses, and indemnity and discussions, and just all of that kind of space of exclusions and indemnification language happening on both sides, or all sides, I should say. Yeah, and it is a patchwork. I think, unfortunately, the hysteria and the fear-mongering around PFAS is at a fervor that is just really hard to get in front of. And so as soon as you start involving community stakeholders, it's going to be really hard messaging, because PFAS are risks claimed to be cancer and developmental effects on our children and depression of our immune effects. And so the list goes on. And so it can very quickly spin out of control. So again, I think advocating for the proper regulation, legislation, paying attention to that, monitoring the trends, and get all your lawyers involved.
And as those lawyers draft those contracts, if you actually dip the contract in PFAS, it cannot be breached. It will not be destroyed.
It will
Best
be
thing you can do.
But it's a really great question.
Yeah.
I have also a question for you.
Yes, sir.
Dr. Anderson, I'm Blair McBride from the Northern Miner newspaper. So can you talk a bit more about the implications of PFAS for mining companies' liability insurance? Exploration sites' liability insurance?
Yeah, that's a great question. I can't. I'm sort of on the environmental side. when you have an environmental concern and a release, I do know that PFAS have been a hot topic in insurance policies and environmental claims management and all of the sides of that for a really long time. And I think it comes down to the contract language and defining that liability and working with your insurance carrier to understand that. And there's whole consulting firms now that are doing sort of legacy insurance investigations. What was your policy when? What was the language? What happened over time? So that's a whole area of specialized expertise now that's outside of my area for sure. Yeah, I don't know if anyone else has experience with that, but.
Any other? Yes.
Is this on? Hi, so two-part question.
So first introduce yourself.
Yes, apologies. I am Pawan Kapoor. I'm from Finaptive Solutions. We work with data and financial reporting. My question is in my field, of course. So number one, do you find that many mining disputes arise from poor reporting processes? And number two, what are the low-hanging fruits, the easiest, most high-impact sort of areas where reporting and data collection can be improved at the operational stage within mines that can prevent mining disputes?
I guess we can all step in and have something to say about that one. But as I mentioned, for instance, in my discussion about food protection and security, even for that seems to be so far removed from what is an accounting discussion or reporting discussion. I myself mentioned that this is critical, right? Because you have to keep track of what's going on. So that then you can establish or you can substantiate whatever claims you may have against a sovereign if that is the context. So I think it is very important. I guess that we may also hear from our expert to my right discussing baseline studies and how you take those into account and whether, because I'm assuming that people would have a tendency to say, okay, if I run a baseline study, I want to keep it under wraps and privileged to the extent possible, and so the problem there is if you start reporting based on that is complicated. So I guess there's a tension there.
Yeah.
So because I'm guessing that you do have baseline studies being run, but nobody wants to talk about them. So again, I think that there's a tension. I think an inherent tension for some things. You do want to have those things on the record. You want to have reporting and regular reporting. So if you start having issues with the government and those issues are creating problems for you, You want to have them on the record, because if you don't, that's going to be something that the tribunal will actually pay attention to. Because if you're trying to protect, say, the value of your shares, which is completely legitimate, but at the same time you don't record that because of that reason, then it's going to be hard on you if you want to establish that in front of the tribunal that you knew this all along, this was creating all sorts of issues, but we said nothing about that. So there is a balance to be struck. There is one with chemicals, there is one with food protection and security. I'm pretty sure the same happens with FCPA, right?
Yeah. With the FCPA and some other potential wrong behavior, it's a little bit more tricky. Over the years, I've heard many times, companies say, okay, one of the first things we need to make sure we do to be on the right side of anti-corruption is keep records of everything we are doing. I say, no, man, no way. The first thing you need to do is make sure you're doing the right thing. That your behavior is in line with the applicable statutes, with your policies, procedures, risk profile, all of the likes. Then it's very important to generate data that can be analyzed eventually, like Agustin is explaining, to be used as evidence that you had the most prudent behavior possible. That you cannot guarantee that nobody will ever, pay a bribe. This is a company, massive company, thousands of employees, global company. But sometimes, some executives make the mistake of thinking that so long as I have data, I'm on the safe side. I say, no way. There is a lot of data about wrongdoing, right? So make sure you have the right behavior, then you take care of that evidence, as Agustin was saying.
Yeah, no, that's super helpful. Quick follow-up. So something like a baseline study would involve like a third party coming in and conducting those studies. So it's, yeah, of course, exactly. And so that would involve its own change management, so to speak. If you need assistance from the operations team and the management and all of that. So like, I was thinking more along the lines of like on the ground operations today. I'm in a mining company, for example. I'm thinking I'm already generating a ton of data. What can I leverage that I already have, which will be basically an easy sell to for the adoption of those ideas. So what are those sort of like low-hanging fruits that I can leverage that I already have? Like I'm already producing that data. Which one of those can I like pick and choose so that it's one, it's easy to sell to people who are going to give me that data, and two, like there's a quick sort of outcome from that if the question makes sense.
I think from my perspective, what work we do is we take all of the great data and all of the disparate, facility management and operations and emergency response and pull it together with one frame. Like, what is the potential risk of use of and an environmental or human health liability associated with this class of chemicals? So it's different than having the data, but it's how are we looking at the data and interpreting it when it's not like it's a bright light with PFAS shining right here. You've got to do some work and you've got to identify the red flags and say, okay, this is a potential flag that indicates we might want to chase this down later. And that's where you work with your lawyers to say, how would you like us to word this and what documentation does it go and how far do you go in the investigation? Sometimes the investigation goes towards sampling a product independently to taking those environmental samples. Sometimes it doesn't. It just is really going to depend on more of the legal guidance and strategy at that point. But from our perspective, taking all of that data, but interpreting it through the lens of what question are we trying to answer? So if the question is there a potential environmental liability associated with unregulated or soon to be regulated chemicals that might be causing environmental or human health concerns? How can we pull that together? How can we answer that question and start putting together the documentation in the repository so that the question can be answered succinctly, quickly, or if there is a problem that does materialize, say there is a drinking water source nearby that suddenly becomes impacted and the community points fingers, right? How can you quickly and best respond appropriately, right?
And let me add to that because, and funnily enough, I see, she's from GSI. I'm not talking about her, but a colleague of hers working for GSI, and I see another colleague here. We were involved in a case a long time ago where we were anticipating things. So many times you have to deal with baseline studies as a sort of forecasting or sort of crystal ball type exercise where you say, okay, this is the operation we have. what can agencies do in the future if they try to come up with something that can, say, set off any claims I may have in the future, how they get creative about this. And so you have to anticipate things that others might do against you. And so you run your baseline studies, you keep them under wraps, under privilege, and say, okay, let's have this in place, because you never know what's coming my way. And so perhaps that is not part of your reporting, because it's not something that is capturing that anything is wrong, but there may be something in 10 years' time that they may want to bring against you for whatever reason, and so you have to anticipate. And I think this is something that, in this case, that again, I'm not disclosing any names, but we work together. I think it's very important that as lawyers and engineers, we can sort of anticipate things, and perhaps it's money that you can think, okay, this is sunk cost, and I'm never recovering for this. But I mean, 10 years later, it may be critical to a very, very relevant dispute you may have with the sovereign further down the line. So I think it's pretty important.
Yeah, that's great. Thank you.
I think we have time for one more, if need be. Yeah.
I have a question for Mr. Morales. So the issue of corruption, what's the solution, or what kind of commentary would you offer in situations where exploration or mining companies working in some parts of the world where corruption is necessary or else nothing gets done? So there's a two-part question here. The second part is, or in cases where Western companies are competing for access to mineral deposits with Chinese companies that aren't as accountable to shareholders as Western companies are.
So if I understand correctly, you say I can only do business if I pay bribes.
Yeah.
So then I say, take a look at the regulations in that country, take a look at the regulations to which your company is exposed to. By the way, take a look at the regulations that you are exposed to as an executive to the company. And most likely you will find out that paying bribes is legal. So there is no way out. Unless you try to think of how can I make it happen without being detected, or that kind of approach, which I don't think is the approach of any global company, right? So, what you see in practice is, in those scenarios where companies actually realize that there is no other way, many times they simply decide to walk away. Because when a company gets exposed to the consequences of corruption, it's not that the company can allocate the cost. Let's suppose you have operations in country A. For whatever reason, somebody, dealing with those operations decides to pay a bribe. There is a penalty to the company because of paying bribes, and the case goes public. You cannot allocate the consequences of that action to that subsidiary in country A. It will be your company globally. So, it's super easy. Just Google FCPA settlements, right? And you will see so many companies that got exposed to these type of situations, and it will be even difficult for you to find in which country the facts under investigation actually happen. You will see this company involved in this industry being penalized with this massive fine for paying bribes. And then, and I think this goes back to disputes as well, as a company, most likely you have signed agreements where you committed to comply with certain anti-corruption standards, FCPA and other regulations, right? So you could potentially be in breach of those agreements. Even more difficult, we discussed supply chain. You said, quite a few good points there about supply chain. Maybe, I have a fantastic supply chain, but suddenly one of, my suppliers decides that they don't want to do business with me anymore because I represent a higher degree of risk. Maybe I had a, potential investor who decides to walk away. The cases we were discussing, the M&A deal. So one common denominator usually in cases of corruption is they can easily get out of hand. If it's a global company, like most mining companies, right? you will potentially have an overlapping of authorities. So you may have an authority under the FCPA pursuing the case if you're exposed to whatever, the UK Bribery Act, another global statute. Even the French have a strong, anti-corruption piece of legislation. And on top of those, you may have the local authorities in whichever country the action is happening. So it's not easy. It's extremely expensive in every sense of the way. So it's not easy. But I think that the specific answer to your question is, if a company concludes that the only way to do business is paying bribes, and they know that paying bribes is illegal, I mean, walking away should be the way to go. There is no other way to it.
And I think that brings that to the end. Thank you again so much for coming today and for sharing your views and questions with us. And we'll stay a bit longer so we can now have one-on-one conversations. And please help yourselves to get some food and drinks if you haven't already. Okay? Thank you so much.